Hi, I'm Kylie and welcome to this week's episode of Money, 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 where we cut out the jargon and talk about all things financial. Hi and welcome back to Money, Money, Money. Today we're going to be discussing the typical legal problems that some homeowners can run into. And to help us run through those, I've got with me Rain Squires from Greenstone Legal, and he's going to answer some of the questions that I've brought in from our clients. So Rain, I've got them written down so I don't get them wrong. And the first one we have a lot of clients that are guarantors for in particular their children's loans. So one of our clients has said, I've agreed to go guarantor for my daughter and her boyfriend to buy their first home. The bank says I need to see a lawyer before I can sign the guarantee. Why is that?
It came into place, it would be a good 10 years that we've seen it in place in Western Australia, but it is across the country. There were a few notable court cases where guarantors, particularly parents where there were language barrier issues, wriggle out of guarantees that they had given for their children. And one of those cases went a long way within the courts, and as a result of the decision, because in that case the guarantee was set aside basically on the basis that the court wasn't comfortable that the parents had understood the legal effect of what they were giving in that guarantee, that now banks across the board have in place a practice for guarantors whereby they must first go to a lawyer and get advice on the guarantee documents and the underlying effect of those documents, and then the lawyer signs a certificate at the end, which that guarantor takes back to their bank, and they say, here you go, and then the bank will allow them to sign the guarantee. And then if down the track the borrower, in this instance their child for example, defaults in their loan commitments to the bank, and the bank wishes to exercise their rights and pursue the guarantor, the parent, the parent can't say, well, I didn't understand it, because the bank will produce that certificate and say, well, I'm sorry, but we're going to rely on this certificate. And and that's basically the effect of it. So and the courts give a lot more credence to a guarantee. They're a lot more comfortable in thinking, well, actually, no, you've had legal advice. We're comfortable that you understood it.
So it's protecting the bank in effect,
isn't it? It's an insurance policy.
Yeah. One thing in there, because we're trying to sort of ease off on jargon that's used a lot, and we hear a lot, the loan was set aside. What does that actually mean?
There have been some cases, and I've acted for both banks and for borrowers in the past, basically where there have been issues regarding the practice surrounding the loan being given. There might have been allegations that the bank didn't follow due obligations and rules, procedures in place, particularly under the National Credit Code. Or there might be other factors. The courts can, in certain circumstances, set aside a loan commitment or a contract set aside. But even if that occurs, the court will still expect and require the borrower to still account for the benefit of the monies that were given to them. So they might relieve them of certain interest in all those obligations under the contract or the loan agreement, but they're still going to be expected to hand back to the bank what they got. They can't benefit and say, well, we're not going to pay that money back and we're going to go off now with the benefit of that.
Yeah, so they can't keep the house.
Yeah, you can't have your cake and eat it too.
Okay.
So you might get out of certain things with interest and fees and charges, but you're still going to be expected to repay the underlying loan advance.
Great. Thanks for clearing that up, because we actually get asked that quite a bit.
Yeah, you never get off scot-free.
Yeah, there never is with a bank, let me tell you.
No.
Okay, so next one, and this is a big one, I think. My neighbour wants to replace our dividing fence, but he wants a brick wall and we want colour bond. Who gets the final say? Because this raises its head a lot.
Yeah, we've seen it happen, and you'd be surprised at how entrenched people will become when it comes to fences. Particularly with retirees, I suppose maybe because they're looking at the fence all day long. But no, we've seen it happen. Basically, under the dividing fence legislation, in a nutshell, you firstly have to establish that the fence that's currently there is not a sufficient fence. And there are rules about what that means. But in a sense, if you've got an old asbestos fence and it's dilapidated and, you know, bits of the asbestos fence are leaning over, you've ticked that box that, it's not a sufficient fence anymore, it needs to be replaced. And then, okay, well, what sort of materials do we use? And where you can't agree upon what type of fence for your neighbour, because ultimately under the dividing fences legislation, you're going to be 9 times out of 10, 50-50 liable between your neighbour and you. So cost is going to be a factor because you're sharing half of that cost. If you can't agree, then you'll have to go to the court, the magistrate's court, and the court will basically look at, what's more expensive?
Yep.
It might be that you want a brick wall to match your house, but you're putting the neighbour to unfair cost. If you're willing to cover the extra cost involved in that, then the court might allow you to get your way. They'll also look at the surrounding fences in that neighbourhood. If you're in a coastal location and no one has colour bomb because they're concerned about rust, that might be a factor. If you're next to a national park and there are issues with termite infestation, dieback, they might not allow you to have a hardy plank fence. So those sort of factors regarding what's normally used in that area are taken into account. So the court will hear from both parties and make up an overriding decision, but they'll have regard to cost. I think that will be the utmost consideration, and the surrounding materials. Is it going to stand out like a sore thumb?
Yeah.
Do they want a really weird colour for their colour bomb fence? The court's not going to be unreasonable, but they're going to try and be fair to both sides.
Can be an expensive way to decide on a fence, can't it?
Yes, it can. And as a lawyer, you feel bad because everyone says, lawyers make, disputes where there aren't any. And when you have those sort of matters, that can't settle and have to go to court, you do feel like the bad guy, and the court does look at you like you've stirred the pot, but you have tried before that point to get them to agree.
To get there. Okay, so moving on from fences, and this one is pretty relevant right now. My partner's FIFO and has just been retrenched. We're way behind on our mortgage, and the bank is now threatening to take our home and to put us into a mortgagee sales situation. What can we do?
Well, I suppose the first thing you would do in that scenario would see, I would recommend, a financial planner or advisor or your accountant to just loan company.
Yeah.
But you'd really need to do it in consult. You really would want to have a roundtable meeting with you guys, your accountant who knows your financial circumstances, and sit down and brainstorm, well, is there a way of restructuring this? And you don't need a lawyer for that. If you have and you have your accountant, that's fine. If following that meeting you're of the view that you can't restructure that loan commitment and there isn't any other way of sorting this out other than to sell the property, and 9 times out of 10 it's better if you can sell it, because if you hand it back to the bank and they have to undertake the process of selling it, whilst the bank is required to do use all best endeavours to sell it and maximise the sale price, as soon as word gets around that it's a mortgagee sale, people take advantage of that. 9 times out of 10 it's advertised as a mortgagee sale and there's no reserve. And also the bank's fees in terms of going through that process, they'll appoint agents, and that's all costs that will come out of your whatever's going to be left at the end of the sale if you are going to get something. So if you have to sell it, and you want time and you can't agree with your bank to get that time, then 9 times out of 10 for residential home loans, the best option would then be to apply for hardship under the National Credit Code. And you guys can advise your clients about that. But there is a procedure in place, and if you can't agree at first instance with the bank under that hardship provision, you can then go, depending on which bank it is, to one of 2 ombudsmans. And they can, they're government set up bodies and overseen by government and the industry itself, and they facilitate the bank coming to the party and negotiating a fair, realistic period of time within which you have to sell the property yourself. That's usually... And
they don't let it drag on indefinitely, because we have seen some clients where they've expected to go on for years until they get the price that they want, but they don't allow that.
No, it needs to be fair. I mean, and at the end of the day, whether it's the court or an ombudsman or anyone, they understand where the bank's coming from. And as a home owner and as someone that's paying their own mortgage off, it's in everyone's interest that the banks exist and are looked after to a degree, because otherwise interest rates for everyone else are just going to go through the roof.
We don't want that.
We don't want that. So there needs to be a fair and equitable system, and there is, but you just need to know where to go and go and see the local loan company and speak to them. earlier rather than later.
And that's the key to it, getting in
in
early before it's actually got to that point where
Completely.
there's a mortgagee sale about to occur.
Absolutely.
All right, now here's one. The neighbour's retaining walls collapsed and has fallen through our fence and into our backyard, including our pool. Now they won't pay for any of it. Backyard's a wide open mess. What can I do about that?
We've had that happen with one of our clients last year, and it was really bad timing because they were actually getting all of their backyard landscaped and ready to roll for a sale. They wanted to sell.
Oh, that is bad timing.
Yeah, it was bad timing. And just as this all happened, going into winter, they had a storm and soil got washed away, and they had this awful limestone retaining wall. Just the blocks just came through the fence into their pool.
Wow.
And it was just a mess. In that instance, it was fortunate in that the retaining wall was entirely on the neighbour's property, so that under certain building legislation made them, we argued, wholly liable for repairing that retaining wall and rectifying all of the consequential damage that had resulted from the retaining wall falling. And there was an insurance report that had assessed it and said that, you know, this wall was clearly built deficiently. There weren't proper materials used to put it in place and cement it. And there was also a question about planning approval. But unfortunately for our clients, you know, absent legal action, we just couldn't get the other homeowner, the one that owned the wall next door, to come to the party. So unfortunately, in that case, they've had to have recourse to the courts. But you know, with anything in the court, it takes time and it's still ongoing. And in the meantime, they can't sell their property, they can't use their pool.
Wow.
There's issues about the pool now not having a sufficient fence around it for the pool fencing rules.
Oh,
the local councils,
yeah.
you know, heard about that, and they've tried everything. They've had their local member of parliament come out in the hope that the local member of parliament would intervene and somehow assist. They really have exhausted everything that they can possibly think of. But the local council can't get involved without, you know, a court order.
So the chicken and egg.
Yeah, the
right?
chicken and the egg.
Yeah.
And in the meantime, they just can't sell.
See, I'd just assume that the insurance company, like you're insured, I guess if you're not insured, there's a problem, but insurance versus insurance, and that in itself is an issue, isn't it?
They went to their insurance company, but then they came out and assessed it, and they said, well, this wall was defective, we're not agreeing to cover, you need to take legal action, and we're Barleys, we're out.
Boy, yeah.
Which is unfortunate, but I mean, you don't really want to, you'd rather see your neighbour than see your insurance company.
And it does happen because you've had a client, we've been asked the question, so usually it's about a tree.
Yeah, trees
making
are
a
the
mess.
common one.
Yeah.
But the issue is now that the longer it takes to rectify this wall, we're now seeing issues in this particular instance of my client with all the other retaining walls with other neighbours are now starting to crack. There's a shed on the higher land that the concrete pad's now starting to split because there's clearly subsidence happening. So the longer it takes, the more issues are coming, the more neighbours that are now going to potentially be involved in the legal proceedings. All over initially just a simple retaining wall.
Wow. Without possible planning
Yeah.
permission. That's a good lesson. If you're going to build one, get planning permission.
This is it, and
Yeah.
you know, they didn't realise this when they bought their property. You know, and you know, now some years have passed, and it's, you know, too late.
Yeah. All right. Now we're getting lots more clients now that have properties that they're putting up on a site like Stays, and somebody has told us that a guest gave them a really bad rating on Stays. Consequently, bookings have gone down. They're losing revenue. They want to force it to be removed from Stays. What can they do? Because they're not getting a lot of traction on this.
Well, yeah. I mean, I've used Stays before, and sometimes you're quite honest in your feedback in your review,
Which is what you want.
Which is what you want,
Yeah.
and that's what Stays' whole business model is sort of being set up around, so that they would always be reluctant to sort of intervene in that instance.
Which is understandable.
Understandable.
Yeah.
But if you can establish that the content of the review is factually incorrect, your first port of call should really be to contact the person that stayed at your property. Point out those inconsistencies and say, look, this actually isn't true. You know it isn't true.
Yeah.
We have got this evidence that we, you know, submit, you know, the cleaner's report before they handed over the keys to you, whatever the scenario might be. Please instruct Stays to take it down. because Stays has, like most of those platform companies, they have there's guidelines which they publish on their website, and there's terms and conditions with respect to their website and putting reviews on there. And if you read through all of those guidelines, there is material about it must be factually true and correct. So if you can get the person that stayed to agree to that, and then you can go to Stays and say, look, we've got this issue. We're losing bookings, we're having people cancel, we're losing deposits. It wasn't correct, and now we have the consent of the person that posted it to take it down. Please take it down in accordance with your guidelines. Try that, and I would hope that that would result in it being taken down. But sometimes with any large organisation, there are levels of bureaucracy that must be, that sort of request can go through. And if it's going to be a matter of taking 6 to 8 or 12 weeks for that to happen, and you're going into summer with a beach house on the beach, and you're losing your peak season, you might need it to be expedited.
True.
And if worst case scenario, we never encourage clients to resort to this unless there's no other option. If you are in risk of losing serious income as a result of this, then the other option is always to seek a court order. But that's not a straightforward option. So I'd always try going to the person that stayed and then going to Stays, but just remember to review Stays' terms, conditions and guidelines.
And I have to say, I've always found the comments on Stays really great. So if someone's being malicious, in this case it's a different question. So I've got 2 quick questions. First, and this is one we do hear a lot about, I've got an investment property, it's been trashed by the tenant, I want to keep the bond and sue for the rest of the repairs. Do I have to see a lawyer?
You don't have to see a lawyer. It depends. If you have a property manager, accredited a property manager, they will know. In Western Australia we have the Residential Tenancies Act, which regulates, very heavily regulates the rental property market for residential properties. So your property manager should be well versed on what your rights are and how you can apply under the Residential Tenancies Act for an order from the Magistrates Court for the disbursement of a bond, and for an order for potentially for damages for the cost of repairing the property. So there is that clear system in place. If you don't have a property manager, then yes, I would suggest that you see a lawyer. Even if you ultimately then go on and undertake that process yourself, it's always good to have seen a lawyer, understand what your options are under the Residential Tenancies Act before you do anything further, what the procedure is, what the timeframes are, what the likely outcome is, and what sort of evidence you will need to gather. You need to get quotes, you need to get photographs, you need to get a report. What was the pre-inspection report? Where is that? Was the bond put into the government account that it now requires, because you can't, as a residential landlord, hold the bond yourself? Have you complied with those rules? Because obviously if we go down to the court to get all these issues rectified, but you have yourself, through not having a property manager, breached all of these other things, we might need to have regard to that, because breaching those things can carry penalties for the landlord themselves. So I think in that instance, if you don't have a property manager, it can never be hurtful to have that advice.
Spending a bit of money could save you a lot of money, couldn't it? So
no one wants to get stuck in the Magistrates Court.
Definitely not. All right, now the last question is, I've just found out someone's lodged a caveat over my home, supposedly for money that I owe them. I don't owe them any money. What can I do? All
right, look, this does arise. It's a serious issue because where someone lodges a caveat over your property, it can obviously restrict your dealings with your property. So if you're about to sell your property, that caveat has to come off. If you're about to refinance and get a new mortgage on your property,
caveat's got to come off.
Caveat's got to come off.
Yeah.
It also, if you look in most home loan mortgages, it actually constitutes a default under your mortgage if someone else has put a caveat, because you're not supposed to charge your property with any other debts until that mortgage is paid off. 9 times out of 10, that's what the mortgage provides. So the first thing is when you get the letter from Landgate notifying you that this caveat's come on, it will tell you who's done it and the address to contact, whether it was their lawyer or the person themselves that claims that they're owed money. You need to contact them.
Yeah.
Hopefully you have enough of a background to sort of set out why you say you don't owe them any money, and give them, a certain period of time, 7 days, 14 days, to remove this caveat. Go down to Landgate and lodge a withdrawal. If they don't, and in this letter, also outline that if they don't, and you're quite convinced that
Yeah.
you don't owe them any money, then you should, if they don't comply with that, then perhaps see a lawyer, because there is a system in place where a caveat has been lodged without due cause, where either yourself or through a lawyer you can ask Landgate to have the Registrar of Titles issue a notice to that person that claims that they're owed money. And that notice gives that person 21 days to either get an order from the Supreme Court extending the operation of the caveat or remove the caveat.
Remove it.
So it puts that person under a time frame to get lawyers, apply to the court to extend the caveat. It's an expensive process. It might be that that's what's required to get this caveat off. It at least brings it to a head under a set time frame.
Yeah.
So in that way, if you've got a sale or a refinance about to take place, you can get on with that.
Yeah.
So there is a system in place to deal with it. Try speaking with them first, and if they don't comply, then see a lawyer and go from there.
Go from there. Well, I think we could go on for a long, long time about the different problems that homeowners face sometimes legally. So we'll probably get you back in for another episode, Rain. Thanks for joining us today, and we'll see you next time on Money, Money, Money.
Thanks, Kylie.
Thanks for watching Money, Money, Money. If you liked this video, hit the red subscribe button. If you'd like to know more information, you can follow us on Facebook or go to our website, linked in the information box below.